Hi guys. So today I put together two videos which I will be releasing. They are specifically requests that I have had from people who've left a comment and said, "Hey, do you know, I'd love a video covering this specific topic." This one, this is from Pam. So Pam, I hope this is what you've asked for. If not, let me know. Pam brought to my attention the case of Ritter against Schmidt, and she pointed out a bit of an overlap in some of the circumstances, and there was a bit of I think she wanted to know whether Section 47.1 was being applied in this case. So I went away and had a little look at it. Okay, so let's look at the bill itself, because it's not Section 47.1 that's being applied. It's a different bill. It's the End Enforced Arbitration of Sexual Assault and Sexual Harassment Act, House of Representatives Bill 4445, which is a statute of quite deliberately narrow scope. And we need to look at the limits to apply it correctly and to recognise when it just does not apply. So the statute invalidates pre-dispute arbitration agreements. Those are clauses that require arbitration of future claims. And it also invalidates pre-dispute joint action waivers. Those are, clauses where barring class or collective proceedings. And when we say class action, that's a group of people joining together and on one action. The scope of this statute is strictly limited to sexual assault disputes and sexual harassment disputes. Now, the operative word throughout is pre-dispute. So any agreements that are signed after the alleged misconduct are called post-dispute agreements, and Congress intentionally left them untouched. So why did Ritter's arbitration agreement fall outside of the statute? So this case involved a married couple, Eric Schmidt and his wife, Michelle Ritter. And basically, she wasn't his. I don't think she was his wife. She might have been his mistress. So Eric Schmidt is the former Google CEO, and Michelle Ritter was accusing him of stalking, abuse, and toxic masculinity. In court documents she filed in December 2024 while seeking a domestic violence restraining order against him. Now, she filed the documents on December the 11th, which was a week after her and Schmidt previously come to a written agreement that required him to make substantial payments to her. And she ended up withdrawing it on January the 6th after they came to a new deal. So, I mean, she accused him of quite a lot of things, but the main issue was the agreement was signed in December 2024. So they entered their agreement and arbitration after all the alleged misconduct had already occurred, and the timing is dispositive. So because the agreement was entered into after the alleged misconduct, it was therefore a post-dispute agreement, and HR 445 applies exclusively to agreements signed before a dispute arises. Congress limited the statute in this way because post-dispute agreements are regarded as voluntary and informal, and they're entered with full knowledge of the underlying events. The judge in this case, Judge Small, applied the statute correctly. The court held that the law did not apply because the arbitration agreement was entered into after the alleged wrongdoing, not before, as Section 402 subsection A and 401 subsection 1 and 2 expressly required. The ruling was textually correct and doctrinally sound. Even accepting the most generous possible reading of Ritter's position, assuming she had alleged sexual assault or harassment, her claim under HR 4445 remained untenable. The statute offered her no foothold for a simple and unavoidable reason. The statute only voids pre-dispute clauses. So this statute in particular is triggered exclusively by arbitration provisions agreed to before a dispute arises. That is the irreducible statutory predicate. Her agreement was post-dispute. Ritter's arbitration agreement was executed after the events at issue had already occurred. This single fact placed it categorically outside the statute's reach. Post-dispute agreements remain fully enforceable. Courts have consistently declined to extend HR 4445 beyond its plain text. Voluntarily negotiated post-dispute agreements are not disturbed by the statute, so she can still enforce her agreement. The statute was a non-starter. So absent the triggering condition, a pre-dispute agreement, no argument under HR 4445 could succeed, regardless of the nature of the underlying allegations. So the doctrinal rule. The governing principle, HR 4445, protects survivors from being forced into arbitration by agreements they signed before any misconduct occurred. It does not disturb agreements signed voluntarily after dispute arises, when both parties are fully aware of the underlying events and capable of negotiating with informed consent. Ritter's agreement was post-dispute. The statute did not apply. The outcome was legally correct and entirely predictable from the statutory text. So the temporal dividing line is pre-dispute, post-dispute. Pre-dispute, any agreement signed before misconduct occurs, HR 4445 applies. The clause is voidable at the survivor's election. But post-dispute, the agreement signed after misconduct occurs, HR 4445, does not apply. Agreement remains fully enforceable. So where is this relevant to Lively, Wayfarer and Wallace analysis? And I've included Wallace in there because obviously we have still kind of two section 47.1 cases running. So the Ritter ruling is precise an analogue for the section 47.1 analysis in the Lively matter. Both cases turn on the same foundational principle. A statute cannot be invoked unless its factual predicates are satisfied. Now, I put these slides together before Judge Lyman issued his opinion and order on the section 47.1 fees in the New York case. There has been no judgment at all in Texas for, in the Wallace case. So, but my kind of language here is around the fact that at the time, Judge Lyman had not found specific things. There had been no finding up to that point. We now know that he has, kind of twisted himself into a pretzel to do so in New York. So just kind of keep that in mind. At the time that this slide was written, there hadn't actually been an opinion and order, and but I'm going to still go with it because in Texas there still hasn't been these predicates have not been found. So with Ritter, the missing statutory predicate. So Ritter lacked a pre-dispute agreement, the non-negotiable threshold requirement. Without it, HR 4445 was simply unavailable to her, irrespective of any other argument. For Lively, again, Lyman has, pulled these things out of a hat in New York, but no such finding has been made yet in Texas. So with Lively, there are missing section 47.1 predicates. library lacks 3 cumulative prerequisites. A Section 47.1 privileged communication. So again, in New York, her communications were privileged under Section 47, right? The litigation privilege and the fair report privilege. Judge Lyman did not initially find Section 47.1 privilege, which is why I've written it like this, but he has gone on since to find it. Something I don't overly agree with, but here we go. So she lacks the 3. So she's lacking a Section 47.1 privileged communication. That's still the case in Texas. She's lacking a Section 47.1 adjudication. So Lyman made a point of saying, I'm not ruling on Section 47.1, and invited her to bring it back. There's also been no ruling on Section 47.1 in Texas. And then the third one is a prevailing party status. Yes, she was dismissed in both instances. Does that mean she prevailed? Lyman said yes in New York. There is a bit of, among legal commentators, there's a bit of, it's not the same as being dismissed on a motion for summary judgment or trial, where, prevailing at trial, where there are some merits test applied. Because part of Section 47.1 does rely on tests on merit, i.e. the good faith basis and the lack of malice. So being dismissed at the motion to dismiss stage before discovery, I personally don't agree that is the point where she should be considered prevailing, because Section 47.1 requires more. Lyman had his come up with his own opinion and made the facts fit, but there we go. So all 3 must coexist. So just to recap, a Section 47.1 privileged communication, a Section 47.1 adjudication, and then a prevailing party status. All 3 of those must coexist before the statute is engaged, and that's the situation in Lively. So the underlying principle: in both cases, the statute cannot be deployed as a sword or a shield when the triggering conditions are absent. Unless your case is in front of Lyman. I'm being snarky now. Come on, Leanne. Courts apply statutory text as written, and that text does not bend, unless you're Lyman. Right, I'll stop it. That text does not bend to suit the facts a party wishes it covered. Now I'm going to say it, unless your judge is Lyman. There, I said it. These parallel failures of statutory predicate are not coincidental. They reflect the deliberate narrow drafting that characterizes both HR 4445 and Section 47.1. In statutory language demands precision in invocation. There you go. That's my viewpoint on that. So Ritter against Schmidt was not invoking Section 47.1, but I can see why but it's a very similar statute. So I think for me the best way I could go at this is to compare what HR 4445 is actually doing and this kind of what it's shared with Section 47.1 and how it differed. So hopefully that will have answered your question, Pam. Let me know what you think of this, though.